gives the children over to my clients. So
Yeah.
I just
Okay.
wanted to clear that up, that I know you're not going to
And
hear it, but she's
right.
misrepresenting that information to the
And
court.
Ms. Cortez, there is a section in the family code that if you voluntarily give up the children for a certain amount of months,
Today's docket is pure family court chaos. OAG chasing arrears, Mom Cortez disputing, and grandparents crashing in for custody. Judge is juggling a nunc pro tunc fix, service issues, and kids waiting in the wings. Stick around. This turns fast. Subscribe, like, and share because every filing here has consequences for everyone.
We were here because the Office of the Attorney General filed a petition for confirmation of arrears, right, Ms. Urubaso?
Yes, Your Honor, that's correct.
It started with your case.
Yes, it did. The confirmation or motion to reduce arrears to judgment and a modification.
All right. Then shortly thereafter, there was a motion. The motion to confirm was filed in April of 2025 and it was set for July. Then there was a motion for judgment nunc pro tunc, which means usually we're going to clarify something or fix something. That one was filed by Ms. Cáceres, Ms. Cortez. Ms. Cortez, just to advise you, and Ms. Cáceres should have given you a copy of it, but she filed a motion for judgment nunc pro tunc, basically saying that the judgment needed to be corrected. At the bottom of page 5, there was something left out, just so you can get a gist of it, okay? So we have to hear Ms. Cáceres' motion.
Judge, the nunc pro tunc, are you looking at Guerra? Because this is
Yeah.
Guardiola.
Ay, sorry.
Yes, because I was like,
No wonder you all, okay. And the other one I think is Justice, hold on. 27743. I apologize about that. Okay, Guardiola and Cortez. And you're going by Cortez or Hennessy, Helen? Helena.
Helena Cortez. Yes, Helena Cortez.
All right. So then what was filed by the Office of the Attorney General was hold on. A suit to modify the child support order, correct, Ms. Urubaso?
Yes.
Right. And then
And
Ms.
reduce
Cáceres filed a petition in intervention in suit affecting parent-child relationship, and you represent the grandparents, right, Ms.
Cáceres, yes.
Cáceres?
Oh, well,
right.
as the
Hold on. And so basically, you all were asking for a change of custody, Ms. Cáceres?
Yes, Judge.
Catherine, I told you to stay in the other room, didn't I?
somebody transferred me over here. I don't know.
No, who transferred her? Did anybody transfer her or you got over here on your own? No, ma'am. No, ma'am. Did anybody transfer her or she did it herself?
I was on the,
I did not
I
transfer.
think you might have transferred yourself, Catherine. So go back to the room.
how do I do that? I
I'll
don't
send
even
you
know.
back. Don't worry. I'll send
I
you
just
back.
clicked accept.
Okay, let me move you. I'll tell you when, okay? There, go to the conference room. Let me make sure she gets there. Here she is. Ms. Cáceres, Ms. Cortez, and Mr. Guardiola. They are appearing.
Yeah.
Apparently, somebody told all the children to be here, so you have two minors under the age of 18, one that's 18, and Kathleen. And I, first of all, because Catherine is over 18, she's not a minor, but this well of the court is only for litigants.
Yes.
You can't have them. And that's number one, but I separated her because she's over the age of 18, she's 21. If she's going to be a witness, she should be under the rule to where she's not listening to your all's testimony so that she doesn't get biased or anything like that. So I separated her. The court still has to decide on the other ones, but what we have here is Ms. Cáceres, you filed an intervention. Were you asking for custody of the children?
Yes, Judge.
All right, on behalf of the grandparent.
Yes.
All right, Ms. Urubaso, obviously yours is only a motion to confirm arrears. And modification, you can't modify until Judge Abascal obviously here's the intervention for the custody portion first. So I would assume that that would be non-suited, or we don't go forward on that. The arrears would only leave how much Mr. Guardiola owes Ms. Cortez, separate and apart, unless for some reason or other, Ms. Casares, you're going to be saying that the children weren't even with her or something like that. But
That's correct,
right,
Judge. So
right
Mr.
now,
Guardiola, Mr. Guardiola intends to file a motion to so that the court can give him credit for the support that he has provided to his children directly. And I believe that's why the children are on standby, and my clients are also in my office because we wanted to show the court once the appropriate motions are filed that Mr. Guardiola is in fact supporting his children. Just the children have not been with Miss Helen Cortez in over a year.
all right. And before you give your side of the story, Ms. Cortez, so we have the Attorney General filed their case to determine whether Mr. Guardiola was in arrears and to change the child support amount, but we can't do that portion because Judge Abascal has to hear the custody case. And then in the meantime, Ms. Cortez did file her own pleadings. What she filed was, hold on. She filed a formal response, which is like a general denial. So she's disputing all the items in your motion. And she
Does
also
Bennett get a
filed,
copy?
okay.
Everything was e-filed, ma'am.
So if it's e-filed, it should have gone to her.
She would
Let's
have had
probably,
to specifically put that she served me, Judge.
I think when you deal with the e-file, you have to check a certain box, but I'm not sure, but we can fix that this morning, Ms. Cortez. But she's basically saying she's denying any and all items in your all's petition, Ms. Caceres. So what I do have to advise you all is the only thing that we can go forward today is on the arrears, because the Attorney General can't consider the custody because we're here only for child support. Any post judgments, then those have to go to Judge Abascal. And I think we discussed this last time, and the only thing that got reset today was for the arrears portion. And I think, Ms. Cortez, you had tried to contact the court just to say that you were not agreeing to the intervention and you didn't agree and you wanted to know why the grandparents were in. So just to answer your questions, the grandparents are now a party to this case because they have filed paperwork saying that the children should be not with you and not with him, but with the grandparents. But that's for another judge, okay?
Yes, ma'am. So with the motion to dismiss, that was filed through Mr. Abascal, so I would need to wait on his decision, or what would I
Let
need
me
to
check. I did see a motion to dismiss. Hold on.
do
You remember
to?
Where is it? Do you remember the date you filed it? I thought I saw it.
It was back in October, due to the lacking of the affidavit, the facts, and the evidence.
Could you give me the
And then
title of the document and the date you filed it? Because I only have two. I have your defendant's answer and a response to the hearing. But I swear I saw a motion to dismiss.
yes, ma'am. It was filed October the 24th, and as well as all my evidence October the 24th as well.
And so you're asking that what be dismissed, the custody portion?
Yeah, well, I was served, it does not include the affidavit, it does not include the evidence or the facts. So the standings
I
or anything,
understand that, but you are asking for what to be dismissed, the paperwork that was filed by the grandparents?
against me, yes.
Okay, then yes, that will be heard by Judge Abascal. Before
Okay.
he goes forward to hear the custody, he's got to hear your portion and make a ruling on whether it should be dismissed. But I'm telling you that I don't see it here in the file, but you can double check.
Here's the legal gut check. This court only has jurisdiction for child support today, not custody. So the grandparents' intervention gets punted to Judge Abascal while arrears stay on the table. And if you didn't check the service box on e-file, expect delays. Would you accept orders you never received?
With
Okay.
the district clerk to make sure it's on file. On your motion to dismiss, does it have a file mark copy at the
Yes,
top
ma'am.
right?
Yes.
Okay. Maybe they put it in his cubby hole. Maybe they sent it to him. But anyway, so right now the position the position that the court is taking is we can proceed on the arrears portion, but apparently, Ms. Casares, you are asking, you do not represent Mr. Guardiola, Ms. Casares, correct?
That's correct, Your Honor, but Mr. Guardiola has indicated to me that, and my clients are in an agreement that he's going to be filing a motion to ask the court to give him credit for direct support of the children. So at this point, we would request that the court not move forward with the motion to confirm arrears because my client or Mr. Guardiola has been directly supporting the children while they're in my client's custody, which has been over for over a year already.
All right.
And I'm sorry, there's not going to be any repercussions due to Ricardo not bringing the children back after his visitation?
Yes, there can be. But I can tell you right now, Ms. Cortez, if you are alleging that he picked up the children for visitation and didn't
Okay.
give them back to you, you will need an attorney. Because what that entails is really you should file some sort of a writ of habeas corpus to get the children back and things like that. I don't know that you can do it yourself, but you can tell Judge Abascal, he's the one that's going to be hearing this. You can surely tell him your side of the story. Right now, the only jurisdiction that I have is to hear the confirmation of arrears. And what she's saying is, let's say the Attorney General, how much are you alleging he's behind, Ms. Urubaso?
Your Honor, I can tell you.
No, Ms. Shavasa, yeah.
So according to the financial activity report that I pulled today, as of October 31st of 25, he's behind in child support arrears, behind in child support $10,494.56, and then in medical $1,999.02.
All right. And so what's going to happen, Ms. Cortez, is there was a court order that obligated him to pay child support.
Yes,
He didn't pay, and this is the amount he owes you. What what's happening is Ms. Casares is the attorney for the grandparent, not Mr. Guardiola.
Yes.
To say that she can represent both, I don't know, that there may be a conflict, but he's going to file paperwork asking the court to give him credit for the time. And you're saying credit for the time that the children were with grandparents or were with Mr. Guardiola?
Well, Judge, they've been
With the
with the
grandparents, right?
grandparents, and
Okay.
Mr. Guardiola has been directly supporting the children, which is also another reason why the children are on standby, and they don't want to go back to mom. They're 16. And
Okay,
in
well, that is
addition,
for Judge Abascal, though. They shouldn't be here in my court. That's for Judge Abascal. The only thing that they can testify to is payments But what Mr. Guardiola has to understand, Mr. Guardiola, is there was a court order that said you were supposed to send the money to the disbursement unit, not the children. So the fact that you didn't send it to the disbursement unit, you could be held in contempt for that, number one. Number two, the position that the Attorney General could be taking is that the money you gave to the children were just gifts and not pursuant to the court order. That's the other thing. The third position is if they've been this long not with her, then there should have been a motion to modify so that the money went directly to either you or the grandparents or something. You can't just not send the child support in. These orders have to be changed. But those are all issues that the court will consider when we come back. Ms. Cortez, at this time, the court is not going to give him credit. Mr. Guardiola has to file his paperwork. I don't know if he's going to get another attorney. I'll let him decide because Ms. Casares represents the grandparents. Mr. Guardiola, the court is not going to entertain the testimony of the children because the two of them are minors. The money on the arrears belongs to Ms. Cortez. It doesn't belong to the children. So, am I going to give you credit or possession credits? I'll let your attorney, whatever attorney you hire, whether you keep Ms. Casares, if you all determine there's no conflict, I'll let you all present the evidence. Okay? Ms. Cortez, in the meantime, you may want to at least consult an attorney. Okay? So
Judge,
the only, yes.
I've been doing.
I did want to note that Ms. Cortez is misrepresenting to the court that Mr. Guardiola took the children and never brought them back. I have
Okay.
documents signed by Ms. Cortez where she voluntarily gives the children over to my clients. So
Yes.
I just
Okay.
wanted to clear that up, that I know you're not going to
And-
hear it, but she's misrepresenting that information to the
And
court.
Ms. Cortez, there is a section in the family code that if you voluntarily give up the children for a certain amount of months, that's
Boom, accusations collide. Mom claims dad kept the kids after visitation, but grandparents' lawyer says she signed them over voluntarily and calls it misrepresentation. That's not just drama, it's credibility, and judges live on credibility. If the kids haven't been with her a year, why no modification? Who pays support meanwhile?
what's going to happen.
The police report.
Excuse me?
I have the police reports.
Okay, well, remember, those are all issues for Judge Abascal. I guess they could be used here in trying to determine whether or not the arrears payment was due. But Ms. Urubaso, what position were you all taking with regards to the arrears of $10,494? Apparently, he gave it to the children. What position would you all take if you have a position at this time?
Your Honor, without taking a look at all of the evidence that's being stated here, the state is still going to be pursuing the arrearage because we don't have any information showing that any monies went to anyone else.
Okay.
And so our position today, if we were to proceed, would be to confirm the arrears and modify the child support. But it appears that these other matters need to be handled first.
Okay. Well, and in relation to that, Ms. Casares, Ms. Cortez, and Ms. Chovasa, we have the two oldest children. I don't know how far back the possession goes. I don't know how far back the monies that he gave the children. I don't know how far back it goes. I can tell you that the court is not going to be hearing the testimony of two minor children with respect to whether they got child support or not. Can I hear the oldest one is Catherine, the one that I separated, and she's here today. She's an adult. If the payments came anytime after she was 18, I can't stop her from testifying if she's been called as a witness. Okay. Same with there's another one that's already, there's two that are, one is 18 and two are under 18, correct?
Correct.
All right. Is the 18-year-old still in high school?
I don't believe so.
Okay. Well, then the question begs, is the court going to hear that the child is already emancipated. So if he or she is going to be brought as a witness, then I'll hear him or her testimony regarding payments. But you still have to remember that the money did not belong to the children, and that there's still a court order that said it was supposed to go directly to the disbursement unit. But I will let your attorney advise you, Mr. Guardiola, okay?
Okay.
And Ms. Cáceres and you will decide as to who's going to represent you, because right now Ms. Cáceres represents the grandparent. So I'm almost confident that she's going to talk to you, or if you're going to get a separate attorney. And so we're going to reset it on the arrears only, which is how much does Mr. Guardiola owe? Okay.
Supposedly.
And
Oh,
I don't think we need to wait for the other portion of the case, since the Attorney General is not going to go forward on the motion to modify the support. We're going to let Judge Abascal set the child support. So if it's only the arrears, I think we can do it on January the 13th. January 13th, Ms. Cortez. That gives everybody time to consult an attorney, okay?
Mm-hmm.
January 13th.
Yes. And if you have any motions, you file them, Mr. Guardiola, and just send me an order to set it, and I'll set it your motions for the same day. Same with you, Ms. Cortez. If you need anything set, but right now what the court is setting is the confirmation of arrears only.
Okay.
And then I'll let Judge Abascal deal with the intervention. Ms. Cáceres will probably get a setting over there.
Judge, and we were able to track down what Ms. Cortez filed, but we did not get served. So she didn't check the box of service. So she can please email that to us so that we can get proper
You have
notice of
her
the
email,
filing.
Ms. Cortez.
I believe so, yes.
Okay. Yeah, I think when you're e-filing, you have to check a box when they ask you, who do you want the machine to send copies to? And you have to put the attorney's names and their email.
I haven't gotten anything from Ms. Cáceres. I haven't gotten,
You got
any,
served.
I just
You
got,
didn't get served?
yes, I just got this one document.
Okay,
And-
that's the only thing that she has filed, is that one, the one you got served with.
Oh, okay. Okay.
Okay? All right. And we'll see you on the what did I say, the 13th? Yes. Thank you.
Thank you, ma'am.
Thank you.
Mhm.
Thank you, Ms. Cáceres.
Maybe excuse, Judge?
Yes, you may. Thank you, Mr. Guardiola.
Claudia Elena Rodriguez.
Okay, and what is the name of the child that's party to this suit?
Gael Rodriguez.
And what is his date of birth?
February 11 of this year, 2025.
Oh, okay, so just a baby.
Mhm.
Okay. All right. And
Oh.
Mr. Gaitan is the father of the child, is that correct?
Yes.
Okay, and Your Honor, we have a DNA test report. Let me share it with the court. Open. If I may, Your Honor, I'm going to share my screen.
Yes, you may.
Ms. Rodriguez, I'm not sure if you had an opportunity to take a look at this, but this is the, oh, it's so small.
That's okay. The DNA test, I can see it.
Okay,
For
yes.
Guillermo Gaitan with the child Gael Rodriguez showed that there's a 99.99 probability he's not excluded. The DNA test will be admitted. You can stop sharing it, Ms. Urubaso, and the court finds that based on these results, he is the biological and therefore legal father. So this will be a parentage order.
Yes, thank you, Your Honor. Ms. Rodriguez, have you had an opportunity to speak with Mr. Gaitan?
No.
Has he visited with the child since the child's birth?
So he was aware of when I had a positive test. He was aware, but he was absent the whole time being. After birth, he visited on August the 4th. He reached out at 4 in the morning. I let him come through. He came, saw my son for 5 minutes maybe, and he stayed talking to me for about 2 hours, and I haven't seen him since. He reached out back in September a couple times, but he hasn't came to see my son.
I see. Okay. Do you have any safety concerns regarding Mr. Gaitan
As far as like,
as far as your interaction with him or interaction with the child?
no, I don't. There's no, yeah.
Nothing?
Uh-uh.
Okay. Was he, when he reached out to you at 4 o'clock in the morning, was he sober?
No.
No. Do you think, okay. So,
I mean, with that being said, I guess, I mean, he does like to go out. He does like to drink. That would be one of my concerns if he's going to be under the influence while Gael is in his custody or his days of visitations. So, I mean, I don't know how his lifestyle is now. I haven't spoke to him
mhm.
maybe since September. And when I did talk to him in September, he was at work. So,
Okay. So if you, so you're asking for sole managing conservatorship based on the fact that he has not been an active participant in the child's life.
yes. Yes, ma'am.
Okay. And you are okay with some kind of visitation? You're asking for a phased-in visitation since the child's not met with dad at this time.
Yeah, I
Uh,
wouldn't feel so like comfortable letting him just go on because he's basically a stranger to him. So I
I
would want um for him, if he wants to come visit him on those days, for it to be at my home.
okay. And you're
Because
okay with him going to your home?
yes.
Okay. So you want to do 2 weeks on, then I guess he works 2 weeks on and then 2 weeks off. So
Yeah, he works 2 weeks on and then
Mhm.
2 weeks off. The 2 weeks that he's off, he's usually in the city. I know he's here. He just, doesn't come around.
Right,
But
right.
I know he's in the city.
But and so you're okay with him visiting 2 consecutive Saturdays out of the month if he decides to do so.
Yes, ma'am.
Okay, all right. So we have first 2 consecutive Saturdays supervised from 12 to 4 for 24 visits. That's what you're asking for, some supervised visits, so the
Mm-hmm.
baby can get to know his dad.
Mm-hmm.
Then unsupervised second phase with 2 consecutive Saturdays. Oh, wait, for the 2 consecutive Saturdays from 12 to 4, and we're going to do that for 12 visits. So hopefully that was clear. Unsupervised, second phase, 2 consecutive Saturdays, 12 to 4. Third phase would be 2 consecutive Saturdays again from 10 to 6 for 12 visits. And then the fourth phase, 2 consecutive Saturdays because of his job, from starting at 6 p.m. on Saturday and bringing him back on at 6 p.m. on Sunday for 12 visits. And then we would move into a standard if he completes all those phases. Is that correct?
Yes.
Okay. All right. And you are going to continue to apply for government assistance regarding the health care of the child?
Yes, ma'am.
And do you know if Mr. Gaitan has any other children besides this child?
No, he doesn't.
He doesn't. Okay.
Mm-mm.
And so it looks like the child support officer will testify to some wages that were found. Based on that testimony and what they found, it appears that child support would be set at $733 a month, effective December the 1st of 2025. Are you in agreement to that amount?
Yeah, and then she said something about his like arrears.
Well, yes, we'll get into that
Okay.
in a second.
Yes, ma'am.
Medical support to be paid to the state at $439 per month, effective December the 1st of 2025.
Mm-hmm.
You are asking for a retro child support amount since the child's date of birth in March through November. Based on the wages, it looks like it would come out to $6,586 to be paid at $150 per month, effective December the 1st of 2025. Are you in agreement to that?
Yes, ma'am.
Okay. Let's
How are
see.
the children insured?
Miss Rodriguez, how are the children insured?
Oh, Medicaid?
Okay.
Yes, ma'am.
And you're asking the court for a non-disclosure of your information on the order. Is that correct?
Mhm.
Okay. And court costs are going to be billed to Mr. Gaitan. Are you in agreement to that?
Yes, ma'am.
Okay. Your Honor, I'm going to need to call Miss Summers as a witness
Yeah.
too.
Okay, now will
Judge
you raise-
locks it in. DNA makes him the legal father, then a step-up visitation plan. Supervised Saturdays, then unsupervised, longer hours, eventually overnights. Support is set at $733 monthly, plus $150 toward $6,586 retro, and the court trims cash medical to $100 to keep payments realistic. That's ruling built for compliance.
Testimony of the child support officer. The court first of all admitted the DNA testing and is signing a parentage order with respect to your son. The court will grant the visitation that was read into the record. We start with Saturdays consecutive, 2 from 12 to 4, supervised by you. Then they're going to graduate to unsupervised for 12 visits from 12 to 4, same 2 consecutive Saturdays. Then it increases to 10 to 6 for 2 consecutive Saturdays unsupervised, and then you'll jump from Saturday to Sunday, and then it'll go into standard.
Yes,
The
ma'am.
court will set child support at $733. There is a retro being granted of $6,586 to be paid at $150 a month based on the testimony that the court has received as to his gross monthly of $4,885. In order to assure that the child support and the arrears get paid, the court is granting cash medical of $100, not $439. The court finds this is in the best interest of the child. I will sign the order electronically. Ms. Rodriguez, do you have any questions?
What's that last part that you said? What is that?
Which part? The cash medical?
Yes.
Yeah, the cash medical doesn't go to you, so it's not
Okay.
going to affect you.
Okay.
Because I see that his gross is $4,885 a month. So after take home, it's going to be less than that. And to assure, because his child support is $733
Yes, ma'am.
and then $150 for you. So that's going to be like around $880, close to $900.
Okay.
And to assure that he pays that, I'm reducing the cash medical to $100 that he has to pay.
Okay.
Okay?
Yes,
All
ma'am.
right. That'll be the ruling of the court. Court costs will be billed to Mr. Gaitan. I
Your
will sign
Honor,
it electronically. Yes.
just to, we're saying at 733 for child support though.
Yes.
Okay.
Yeah, we're leaving
And,
it. We don't redo the numbers.
Okay.
It's $733 child support. When you add the $150 on take-home pay less than $4,885, this will be assured that that's the court's ruling.
Yes, Your Honor. And non-disclosure, I believe that Ms. Rodriguez said that she did not
Doesn't need non-disclosure?
Yes.
Okay, then we will remove it. Thank you,
Thank
Ms.
you, Your Honor.
Rodriguez.
Thank you.
Ms. Diaz, you had filed what we call a motion for clarification because you were alleging that the visitation, some of the terms in the visitation needed to be specified or fixed, correct?
Yes.
Okay. And Mr. Elizondo, you filed a motion. I read hers, so I know that she was looking at fixing the visitation terms. Your motion, though, what was the reason that you were asking the court to grant to redo the order again?
An erroneous child support calculation that's impossible for me to suffice, as well as I was supposed to have a hearing. I'm looking to have a new trial. It is my understanding that the court so far has held on to evidence that I've submitted for over a year that could basically amount to potential child endangerment and drug use.
What evidence did you, where did you send the evidence, Mr. Elizondo?
I've sent it to the district clerk, to css-21legal@oag.gov, as well as to uvalde.208@customer service.
Okay. All right. Do you remember the date you send it to CS 21.
One second. It would have been on right on around the 5th, 27, 25, as well as
The date, 5th, 27. You mean May the 27th, 2025?
that's correct. There should be that. I use two. I have two different emails. It might have
Okay,
been.
give me the emails you sent them to.
Okay, so my emails or yours?
No, the emails you sent them to.
Okay. I'm getting that information for you, Judge. It'll be on May 27th, 2025.
The email you sent it to, not the date.
CSC21 at texascourts.gov.
Okay, Ms. De Leon, if you could do a Google search for our email, more or less around May the 27th, to see if it's in there. You said you also filed it at the district clerk's, Mr. Elizondo?
That's correct.
Okay, let me look for it. Now, your motion indicates that you want to set the judgment aside. It mentions only that the child support is too high and that that's not your income, that we didn't set it based on your income. It mentions nothing about visitation. It mentions nothing about arrears or confirmation of arrears. It's not in your motion. So just to let you know.
The child support payments or for the merits in the new trial?
No, I'm looking at your motion to set aside default judgment, and it says modification of child support order, and you're stating that your income is only $2,100 and that we set your child support at $1,800. Those are the terms of what you're alleging was wrong. Okay, I just want to make sure.
I'm sorry.
I just want to make sure that your motion is correct.
Miss, under category, under section 3, grounds to set aside default judgment, on bullet point number 3, it says public policy and best interest of the child. Retaining the default order would contravene the best interest of the child as it ignores substantial evidence of respondents and fitness.
Hold on, bullet point number 3. Oh yeah, there it is. It's on 2 pages. Okay. I see it. You have it on bullet point number 3 on page 1 and page 3. All right.
Thank you, Judge.
Did you find it, Ms. De Leon? No, can you take your phone off of mute? No, I don't need you to print it. I just need you to take it off of mute and tell me if you found it.
Yes, ma'am, I did find, there's 2
Okay.
that I saw.
All right. Now, Mr. Elizondo, on your motion,
Right.
I see here that you did serve her. You served Alejandra Diaz with a copy of the motion.
That's correct.
Did you send it to the Office of the Attorney General?
Yes.
Okay. And I know the district clerk also sent it out because I got an email from the district clerk and they sent it out to all parties, Ms. Urubaso.
Yes, Your Honor, we did receive a copy of the motion.
All right, so what the court is going to do at this time, because Ms. Diaz also filed her motion to redo or to change the order. Hers was only specific as to certain terms, the pickup and the supervision. So hers was a little bit geared more towards the visitation, correct? I mean, the visitation, right, Ms. Diaz?
Yes, ma'am.
All right. And Mr. Elizondo, yours was regarding some of the aspects of the visitation as well as the income. Ms. Urubaso, do you have a response with respect to his motion to set aside default judgment? I have reviewed the file.
Your Honor, the state is, we're not objecting to the motion for new trial.
Now the reset hammer drops. The The judge sets aside the default judgment, admits there's missing evidence in the email trail, and orders a new trial. But she's crystal clear, emails aren't evidence unless you show up and present it on screen. Trial is January 13th, 2026 at 9 o'clock. No excuses, everyone.
And I've looked at it, and I've listened to the tape. I was supposed to listen to the tape, and there's a huge discrepancy as to income, Mr. Elizondo, because they had a child support officer testify as to your reported income, and it was totally different. So you're going to need to listen to that testimony as to reported income. You weren't here, but there is a huge difference between that and $2,100 a month. You
I
really
understand.
should listen. Hold on, no.
I'm
You
sorry.
really should listen to the reported income they have for you. And then, so Ms. Urubaso, we got lost and I've listened to the tape with respect to the arrears, but since she's asking that it be fixed or done again on the visitation, we need to fix it anyway.
Yes.
And then the court is going to confirm that we did have his evidence under the email. And so that was not considered when we came back. And so in all fairness, the court is going to grant the motion for new, or to set aside. We're going to set aside the default judgment, Ms. Diaz, so that we can fix it on both ends, okay? Okay? Ms. Diaz, did you hear me?
Yes.
Did you hear me, Ms. Diaz?
Fine.
I'm having trouble hearing you.
Yes.
Okay. All right. We're going to fix it. We need to fix it for you anyway. If there were some terms that you said it was wrong, we need to fix it on the visitation anyway. Okay.
Okay.
Now, Mr. Elizondo, I'm going to set aside the default judgment. You do have to submit an order. And under the rules of civil procedure, a verbal order, which is what I'm giving you now, is not enough. A motion to set aside the default judgment is timely. So you need to file with the district clerk an order or piece of paper, an order stating that I granted your motion and that I set aside the default judgment that was dated September 16th, 2024.
So
It
I
has
have
to
to
be-
notify, I'm sorry,
No, you have to submit an order.
like the same way that I submitted the motion to set aside the
Yeah,
default
but
judgment.
it's going to submit an order and then I will sign it. And
I
then we will
understand.
come back. I want to give you a chance to present the documents. You did send them into the court, but you weren't here that day. Ms. Diaz was the only one that was here. And I did see in your motion that you got notified a day before. No, sir. You were notified. You were here when both of you were here back on August the 26th, and we reset the case. And I have proof here that you were here. We reset the case to September the 16th. So that date, September the 16th, was given to you in open court. And at the time, on September the 16th, when you didn't show up, I reviewed the court file, and the Office of the Attorney General had filed the reset order, and they included a certificate of service, which means it was mailed to you way back early in September. So they didn't notify you just a day before. But the court is going to set aside it anyway because we need to fix it. Ms. Diaz wants it fixed anyway. And
That's my
so
honest mistake.
when you
My
come
sincere
back,
apologies to the court.
I'm going to give you a date. So on your order, you're going to say the court grants the order setting aside the default of September the 20th, because that's when I signed it. And then right below that, you're going to put that the court is setting the trial on January the 13th. Okay?
I understand. I only have one last question, Judge.
Yes.
If I now have all my evidence in a different format, more ready for me to present it. Am I allowed to resubmit it again, or I have to go
You
based
can
off of the one
submit it, but I wouldn't what happens is you submitted it, but you weren't here on the 16th to present it to the court. You just sent it in an email, and I have the email, but what you have to do as a litigant is you have to show up and say, Judge, here is my evidence, and then you share the screen and we all see it on the screen. You weren't here. So
Yes.
you need to be here, and the date that I'm setting, and you're going to put it in the order. You're going to put in the order and say the court hereby sets your trial for January the 13th, 2026 at 9:00. Until then there's no child support or no visitation, Ms. Diaz. We'll just wait on the visitation, okay?
Okay.
All right.
I understand.
Okay, it'll be granted. We will come back. The court is granting Mr. Elizondo and Ms. Diaz motion to set aside the judgment. It will be granted. The new trial will be on January the 13th at 9:00. Okay?
Okay.
Thank you, Judge.
Thank you. You're welcome. Bye-bye.
Thank you, ma'am.
We had a prior hearing where a temporary order was reached, October the 21st, 2025. Your Honor, we are asking the court to finalize that order. We had, the state or the parties had asked for a reset so that they could potentially get information regarding insurance, and I don't believe that was obtained. The parties are in agreement to finalize the temporary order with joint managing conservatorship and court costs to be billed to Mr. Benavides.
All right, Mr. Benavides and Ms. Longoria, what we're going to do, first of all, just so that you all remember,
I'm out of breath.
if you can move somewhere quieter, Ms. Longoria, so that you're by yourself and isolated.
Okay.
All right, the court will take judicial notice of the temporary orders. Y'all were here October the 25th. Both of you were here. And what we did in that order is we granted visitation. Those are going to remain the same. We also granted cash medical of 113. No, cash medical to be paid by Mr. Benavides of $81 a month. That's going to stay the same. Child support was set at 0. That's going to stay the same. Ms. Urubaso?
Yes, Your Honor.
Okay. And the reason for that is because he's providing direct support?
No, it appears that Mr. Benavides is, are you, Mr. Benavides?
He provides daycare and cost of travel expenses when your son goes visits. Are you still doing that, Mr. Benavides?
Yes, Your Honor.
All right. And Ms. Longoria, because of that, that's why you're agreeing to set the child support to continue it at 0. Is that correct?
Yes, correct.
All right. There is no retro child support, no retro medical or dental. The cash medical is $81 that Mr. Benavides has to pay. And so we were supposed to come back, like she said, for insurance. What did we decide to leave it at the 81, Ms. Urubaso?
Yes, Your Honor, we're going to leave it with direct payments to the state. At 81, Mom will apply for government assistance regarding the health care of the children. Additionally, I think we needed to designate conservatorship, and we've designated joint managing conservatorship for the parties.
All right, with Mom as primary.
With Mom as primary, yes.
Court costs will be waived.
Okay.
Do either one of you have any questions, Mr. Benavides?
I do not, Your Honor.
All right, Ms. Benavides, any questions?
No, I do not.
All right. The court finds that this agreement, we're going to finalize the order. It will be a final order with respect to the child, Raul Benavides. The court finds it's in his best interest to do so. I will sign the order electronically. That's when it becomes final. So you are excused. Thank you very much to both of you for coming to court.
Thank you.
Absolutely. Thank you, Your
Bye-bye.
Honor.
You're welcome.
Jureni Magali Villegas.
And Miss Vegas, can you tell me the name of the child in this case?
It's Regina Sofia Rodriguez.
And what is her date of birth? His date of birth?
It's December 19, 2017.
2017. Oh, okay.
Yes.
And how old is the child?
She is 7 years old.
7 years old now. Okay. All right,
Yes.
great. So have you had an opportunity to speak with Mr.
No, we haven't had any contact. It's almost been 3 years.
Okay. All right. But was he present at the birth of the child?
Oh, yes.
Yes, he was. Okay.
Mhm.
It appears that there's an acknowledgement of paternity, Your Honor, that we'd like for the court to take judicial notice of attached to the pleadings.
All
Or
right.
I can show it to you. We have it.
No, it's okay. If it's attached to the pleadings, I'll take judicial notice. You may proceed.
Thank you. Okay, and so Miss Villegas, you're asking for sole managing conservatorship of the child, is that correct?
Yes.
And do you have, it's because you have some safety concerns regarding Mr. Rodriguez, is that right?
That was at the beginning. Right now we don't really have any contact, but he does see her on the weekends she goes to her grandpa's house, and he does sometimes go and visits her there.
He does go to visit her there? Okay.
Yes.
So, but you're still asking for sole managing conservatorship?
Give me 1 second.
Yeah, no problem.
Okay. Okay, what was the question?
Sorry about so so he's seen your daughter. He is seeing your daughter?
Yes.
Okay. But you're still asking for sole managing conservatorship, is that right?
What was what would that
Has
be?
he ever harmed the child, Miss Villegas?
Oh, no, never.
All right. And so he visits him, but you take him to the grandmother's, and that's where he visits him?
Yes. And it's only sometimes, it's not all the times. It's only sometimes
Right.
whenever he goes.
Well, there's a
Okay.
presumption in the family code that states that joint custody is what's best for the child, but it just means joint custody. Your child lives with you,
Yes.
and the dad will get visitation. You share in some of the rights, and we'll give you the schedule. But the question is, should we not give him joint custody? But if he's not harming the child, he hasn't harmed you, he's visiting the child, I don't think the presumption will be overcome. So what we'll do is appoint you both joint managing conservators, but you will have the primary right to determine where the child lives.
Okay.
And then we'll figure out the visitation. We can continue it the way you want to.
Okay.
But you said he was like 7 years old, right?
Yeah, she's 7 years old. Yeah.
She's 7 years
7 years old. All right.
Yes.
Has your daughter ever spent the night with him?
No.
Okay. How about has she ever spent the night as her grandparent?
Yes.
Okay. And she's been perfectly content and safe?
Yes.
All right. So it seems like when she spends the night with the grandparents, that's when he visits them also overnight?
Not overnight, but he does go like during the day and then spends a while with her, and then he goes to his house.
Back. All right.
Yeah.
What would you like as far as visitation? She's already 7. So what would you like the court to grant in visitation?
He can take her on the weekends.
Okay. Starting Friday or Saturday and Sunday? What would you like?
Saturday and Sunday.
All right. So we can do the 1st, 3rd, and 5th Saturday and Sunday, beginning Saturday at 9 and then ending Sunday at 6. Do you still want to have the grandparents involved at least for a while?
Yes.
All right, then we can do it until she's 7 right now. When does she turn 8? Or do you
She
think
turns 8 on December.
Okay, that's too soon. Okay, we can do until she turns 9.
Okay.
The grandparents to be involved until she's 9 years old, and then thereafter, he can take her to his own house. But we're only suggesting that if at 9 years old he continues to see her with the grandparents, that's fine. Just leave it like that then.
Okay.
Okay.
And that, oh, sorry. And that address is at 1710 Coyunda, Eagle Pass, Texas, 78852 is where the grandparents. Okay, great.
Yes.
And are you going to continue to apply for government assistance regarding the health care of the child?
Right now she has Medicaid.
Right. Are you going to continue to apply for that?
Yes.
Okay. So it looks like we're basing child support on minimum wage, and we have child support set at $193 because he has an additional child living in his household. That would be effective December the 1st of 2025. Are you in agreement to that?
Yes.
Okay. Medical support to be paid to the state at $57 per month, effective December the 1st of 2025. Are you in agreement to that?
Yes.
Okay. Looks like you are asking for some retro child support from November 1st of 2023 to November 18th of 2025, a total amount of $4,194. Is that correct?
Yes.
Okay. And oh dear Lord. And then there's an amount that you're asking for, I guess because this is when he had his child. So it drops down to $203. So an additional amount of $1,218 from, geez, hold on, total judgment. Total judgment, let me just go with the total judgment is $5,412 with a repayment of $60 per month effective December the 1st. Are you in agreement to that $5,412?
Yes.
Okay. And you would like to go ahead and you are asking for non-disclosure of your information.
Yes.
Oh, wait, it says you're not requesting. You're not requesting.
Yes.
Okay. All right. Okay, court costs are to be billed to Mr. Rodriguez. That's all I have, Your Honor.
All right, and you got me a little bit. Okay, the retro is 4,194, and that's based on that time frame at minimum wage, correct?
Right, without a child. So it'd be 11/1/2023 to 5/1/2025. Child support at 233 for 18 months. Then he had the child. So then from June 1st, 2025 to November 18th, 2025, it went down to $203 for 6 months. That was a total of $1,218.
So what is the total retro once you add them all up?
5,412.
So if I'm understanding it, you all just phased in the other children at the time that they were born, correct?
Yes.
All right.
Yes.
All right. Then the court will grant the retro of 5,412 to be paid at what amount?
$80, Your Honor.
All right. Child support will be set at 193 with a medical of 57 beginning December 1st. The payment, $80 payment is also beginning December 1st. Court costs will be billed to Mr. Rodriguez. The court finds this is in the best interest of the child. Was there anything else to add to that, Ms. Urubaso?
No, Your Honor, that'll be all from the
All right.
state.
Ms. Villegas, any questions you may have?
No, not any, ma'am.
All right, I will sign the order electronically. The court finds it's in the best interest of the child, so I will approve it. It will be a final order.
Okay.
Thank you. You are excused.
Thank you.
Thank you, Catherine.
Thank you, Catherine.
Wrap up. Arrears fight gets reset while custody goes to Judge of Ascal. Separate case, DNA confirms paternity. Phased visitation ordered. Support $733 plus retro repayment. Another order is reopened for a January 13th trial. Multiple parents leave with finalized support terms. For more breakdowns, like, subscribe, and share. Comment, stay tuned.